for the issue of making it the most narrow possible way of the exemption applying, that comes from Illinois FOIA case law, where when we challenge a FOIA denial and it goes to the court through the lawsuit, the court has to interpret the FOIA statute, and case law requires the court to take the FOIA statute at its most narrowed interpretation that favors disclosure. So if the court is unsure of how it should end up ruling on whether an exemption applies, it should err on the side of disclosure, which is by interpreting the FOIA in a narrow way, meaning it narrowly applies to records. So that idea is taking what the court is already doing and implementing it as a citywide policy over FOIA.
Or one of our biggest problems is that it seems that we just don't have a proactive FOIA response in the city. The response is, most of the time, is we're going to rely on the burden of suing as being a hurdle too big for someone who wants records to get them.
Yeah, unfortunately, that's a reality of it, is that sometimes we're not sure if a record is being denied because the city would prefer a judge to order it to be released, or if it is some type of administrative or whether it's some type of administrative error on the city side where they're not complying with FOIA. We don't necessarily know, and we can't look into the minds of them every time. So sometimes we do have to take discovery to find out why the FOIA was violated. And there is a provision in the FOIA that looks for willful and intentional violations.